Welcome once again to Lehto's Law. Here's Steve Lehto.
Nathan sent me notes to Steve, check out the story. Another example of people who spent time in prison for a murder they did not commit, being freed through the use of modern technology. But these guys spent a bunch of time in prison for a murder they did not commit. They've been saying that all along. And by the way, now when you look at their case, you go, wait, they were convicted on the sketchiest of evidence. The sketchiest of evidence. So Marla Lundak and Brian Curran wrote this for Fox 11 News out of Green Bay. Brothers exonerated of 1987 Green Bay murder. DNA evidence points to a man who died in 2000. So up until now, these guys have been rotting in prison for a crime committed by somebody else. So for 24 years, the two men have been sitting in prison, serving time for a crime they did not commit. Now they're free thanks to genealogical testing. So this is not the straight up DNA testing that we talk about normally. This is where they actually went into the databases of those companies that were, people send in their DNA, and they did a trace that way. The convictions of two brothers for the 1987 murder were overturned last week. Robert and David Bintz were convicted of the murder in 1987. Both men were sentenced to life in prison. Now, the victim was bartending at the Good Times Tavern in Green Bay back in 1987, and 2 days later was found in a forest nearby, and she'd been assaulted and killed. The brothers were at the tavern that night and were questioned by police in the initial investigation. One of them had reportedly had an argument with the bartender after he believed she had upcharged him for a beer. More than a decade later, while serving time for an unrelated crime, the man's cellmate told authorities that he had admitted to the murder and said his brother helped him. Despite no physical evidence linking the brothers to the crime, they were convicted in 2000. The evidence against them was a jailhouse snitch. And now, I don't know enough about this story, but I can tell you that in Michigan, there's some famous stories out of Detroit and Wayne County where there are some well-known snitches who've somehow gotten involved in a whole bunch of cases. Because if somebody's in jail and they think this person did something, but they're not sure, you put the snitch in with them, and a day or two later, you pull the snitch out, and the guy goes, yeah, he confessed to me the whole thing. And apparently, this guy's really, really good at getting confessions, especially from people who didn't do the crimes. So here, he says, oh, yeah, shared a cell with the guy, and the guy admitted it, and said his brother was involved. So now a Brown County judge was a district attorney at the time. He prosecuted the brothers. He told news outlets, these old cases can still be solved if people come forward with evidence, and if people keep working on it. This case was basically solved the old-fashioned way. I'm not going to take blame for something. I didn't have nothing to do with this, and I swear to God I'm telling you the truth in that. I'm not taking the blame for something I'm being accused of, said one of the defendants on the witness stand at his sentencing. So back in 2000, when he was sentenced, guy goes, I didn't do this. And at your sentencing, if you come clean and admit you did it, they'll often go easier on you because they go, okay, at least the person's taking a step in the right direction by admitting they did it. Now, for a case this heinous, you're probably not going to get off much lighter, but around 2018, the Great North Innocence Project in Minnesota got involved in this case. For 2 years, genealogists worked to find a connection to the blood and other biological things that were gathered at the crime scene in 1987, but they had no luck. That's when the organization's leader turned to the Investigative Genetic Genealogy Center in New Jersey. The program's director there tells Fox 11 that IGG first began looking at this case in 2023. In the case, the DNA from the crime scene was uploaded to traditional DNA databases like the one used by the FBI, but they didn't find anything there. So, at IGG, experts are developing the genetic profile of the crime scene. From there, it's uploaded to consumer databases like Family Tree DNA and GED Match. After that, they begin looking for distant relatives of that sample and begin building up family trees linked to it. The family tree, combined with other context clues from research, can narrow the DNA and identify the exact family it came from. Once we realized we were narrowing in on the right family, there was a palpable sense of joy and relief knowing this was going to lead to a potential exoneration and justice for these two brothers. So that man and the institute there narrowed it down to three brothers in Green Bay, one of whom was William Hendricks, a convicted rapist who died in prison in 2000. The IGG then paid for the disinterment of Hendricks' body from Green Bay Cemetery in April to get a direct DNA sample from his body, and they got a connection. The chances of that DNA belonging to anyone but Hendricks would be a 1 in 329 trillion chance. A motion to vacate the sentences of both men was filed on Wednesday, and so the men were released. Despite this being an extraordinarily intimate crime, state crime lab testing of crime scene evidence revealed no trace whatsoever of Robert or David Bintz at the scene. Likewise, defense counsel's extensive additional testing over the past 5 years found male DNA in blood from the victim's dress, they found blood on the victim's shoes, on hairs pulled from her body that were found on her body but not hers, on hairs from the front of her dress, and on hairs recovered from her clothing. Yet not a shred of it is attributable to either of the brothers. So the victim's body was found between the bar and where Hendricks lived. So this shows that you cannot always count on a confession, especially when there's no record of it. What we're talking about is hearsay. So, hang on. They knew that the blood and other samples found in the victim did not belong to the brothers, but the power of that confession sort of overwhelmed that in the eyes of the jury, and I don't think that's unreasonable. Ordinary people hearing a confession are going to believe it. It's very hard to come to terms with the fact that someone could falsely confess to a crime. So I think just recognizing that reality, making sure that future cases don't rely on that is important. Of course, the problem is that you don't know if the confession existed if it wasn't recorded. So some guy walks out of a cell and goes, yeah, that man confessed to me. He said this, 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 and this. You ask that man, did you tell him those things? No, of course not. Why would I tell him those things? They're not true. Okay, we're to put this guy in front of a jury and let a jury decide. So when the jury hears that this guy's already in jail for something, and he confessed, why would he do that unless he really did it? State prison records show that the men were discharged from sentence this past week. So one got out on Wednesday, one got out on Thursday. They were in different places. Fox 11 reached out to the district attorney assigned to the case back in 2000, as well as the current district attorney, but did not receive a response from either. And so I've mentioned before a couple of things that pop into my mind here. One of which simply is that jailhouse snitches who claim to get confessions, that shouldn't be enough. You shouldn't be allowed to put someone on the stand and go, well, hey, just tell us what you told us you heard. Because unfortunately, jurors think that when you've got this cleaned up person on the stand testifying and the prosecution's put them there, there's somehow something reliable about this. When a jailhouse snitch is told, you know how you're doing 5 years right now for auto theft? If you got this guy to confess to murder, we'd knock a couple years off for you. Now, do you think the guy's going to go in there and go, boy, I hope he confesses. I hope he confesses. No. He's going to go in there, talk to him for a little bit, come back out and go, yeah, he confessed. And the real problem here is that they ask for jailhouse snitches to do these things, and yet they never record them. And they'll often say, but the person confessing said things that only the real criminal would know. And oftentimes they're wrong on that. Oftentimes they feed information to the snitches. And how would we know? Because here's a great example where these two guys had nothing to do with this crime. And we know that now. We know who actually did the crime. Guy's dead, but we know who did it. So there's also a problem because, and I'm not sure they got around this, but in court, when one person allegedly says, I did this with somebody else's help, that's usually not enough for the court to allow that testimony to go against both people. So even, and I'm simply pointing this out, even if a person did testify and say, this guy told me he did it with an accomplice, that statement there can be used against the person speaking, but not against the accomplice. Because if that's all you've got, Talk about unreliable. It's hearsay about someone else. And just for those in the audience who know this, generally speaking, hearsay is defined as an out-of-court statement that was made by somebody other than the person testifying. But the definition is much, much longer than that. So anytime you hear a question that's begun with, tell us what he told you, you're going to get a hearsay objection. However, there are exceptions to hearsay, and the exceptions are quite lengthy and numerous. And one thing that's actually not considered hearsay is an admission. When somebody admits they did something. So if I say, I did it, and you go, what did Mr. Lehto say? Objection, hearsay. Approach the bench. What's your witness going to say? Your witness is going to say that Steve Lehto raised his hand and said, I did it. I did it. That is not hearsay. That's an admission. And the judge is going to go, I'm going to allow that because it's not hearsay by definition. And so if you look up the definition of hearsay, and then near it is this section on admissions, it'll say by definition, an admission is not hearsay. However, the courts need to scrutinize these things. And like I said, have got a serious, serious problem where a prosecutor will put on a trial, put two people on trial, and the entire case appears to hinge on one witness, Jailhouse Snitch, saying, yes, one defendant told me he did it, and he said he did it with his brother. Oh, so the guy who actually did the crime is dead. How about that Jailhouse Snitch? Is that Jailhouse Snitch still around? That's what I'm curious about. So it's a crazy story. It's good the guys got out. It's bad they spent 24 years in prison for the crime they did not commit. We'll have to see if there's any lawsuits or anything that follow up from that, because there very well could be. Nathan, thanks for sending that. From Fox 11 News, Marlo Lundak and Brian Curran wrote it. Brothers exonerated of 1987 Green Bay murder. DNA evidence points to a man who died in 2000 as having been the true perpetrator. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. If you're looking for the deal of the century, it'll take you a century to find a deal.